our attendees feel that they are not able to hear, let them be informed that we have yet to start. Nobody is speaking, so they can't hear anything.
Sir, you're audible, sir. You can start, sir.
It's a very well. Good evening, everyone. We find that there are more than 500 attendees to hear this lecture. All of you are most welcome. Today, me and Mrs. Kiran Suri, a senior advocate, we are going to speak on a topic for which there is no written text available for you, and at the same time you have to write maximum in this paper. In the change scenario, in the sense that in the 50s and 60s, when Supreme Court was established, there was, as a successor of the federal court, there was a need for the local advocate as an interface between the Supreme Court of India and the litigants from various parts of the remote parts of the country. And you have this institution of advocate on record as one, for this reason. This is one of the reasons for its origin. Now the times have changed. You have now e-filing, and the communication is not a problem. Yet, as advocate on record, one of the most relevant thing, or one of the most relevant aspect of this institution of AOR is the presentation of a case before the Supreme Court of India in a very precise, a professional, and a matured manner. Because all of you, when you draft, you have to keep this in mind, that your draft would be read by judges who have already 15 to 20 years of judicial experience, and they do read almost every paper of the paper book, or at least the most relevant part of the paper book, including your synopsis and major dates in your list of dates. Now, therefore, your role as a matured professional who is supposed to be the interface between your client and your role to present the case in a more precise manner with issues properly highlighted is a very important role. Now, as I said, that this is a subject on which there is no text available. So we are going to share our empirical observations and our experience of good drafting and the pitfalls of bad drafting. And Mrs. Kiran Suri has drafted much more than me. So I am going to request her to first start the lecture, and thereafter I will have my sharing of the experiences and observations with you. So Mrs. Kiran Suri, please.
Please. Thank you, Mr. Pallav. Good evening, everyone. Today's topic is drafting, and so far as SLP is concerned, form number 28. We are all aware that nobody can learn drafting in a day, nor anybody can teach drafting in a day or in a couple of lectures. By the time you are appearing for advocate on record exam, you all have some considerable number of years of experience. So I'm sure you must have done drafting either in your own cases or in the cases which in your senior's office, or maybe for a friend or pro bono. More and more you draft, the skill of drafting will be coming to you in that manner. Merely while listening to some lecture or reading some text, you cannot learn drafting. In fact, drafting is a skill which you have to learn with your own experience on the facts of each and every case, because the language for every subject is different. Legal language you have to use for the subject on which you are preparing the special leave petition. Please keep in mind that so far as drafting is concerned, at the Supreme Court level, client is not coming to you. What you are getting is the papers, documents, judgments which have been produced in the trial court or high court judgments. Client is not there who can assist you regarding his own case. So I will put drafting in 4 steps. My first step is that you must thoroughly go through all the papers. When I say all the papers, it does not mean only the impugned judgments. If it is a civil matter, please start from plaint onwards. And if it is a criminal matter, please start from FIR onwards. Because unless you go through all the papers on the basis of pleading without evidence, or on the basis of evidence without pleadings, or any vital document has been missed out, or irrelevant considerations have been taken into consideration while deciding or while recording a finding. These all aspects are required to be seen, because what you can challenge is if the judgment of the High Court is perverse. Every element of these things amount to perversity. It is very necessary for you to go through all the papers thoroughly. And another reason why you should go through all the papers thoroughly is you can always raise a new plea on the basis of existing set of facts. And our experience shows, and reported judgments you must have seen by now, several cases have been won on the basis of new plea in the Supreme Court, which has not been taken in the High Courts. Therefore, you can help your client by thoroughly going through all the papers and finding out maybe some new pleas. One more reason for which you should go through your papers thoroughly is, many times we have seen in the impugned judgment, what has been urged by the party, by the advocate, has not been noted or recorded. In case you want to challenge or you want to say that you have urged this ground before the court, which has not been recorded by the High Court, you have to make out a case that yes, we urged it before the court, and that ground must come in your special leave petition. Otherwise, probably you can't raise it. One more aspect you should see at this stage is that number of from a good cases in Hindi, they said, Satish ne kaha khoon kar do. And when I got the translation, it spoke, do blood. Nothing wrong in it. Similarly, when they said they were another case, paper, when you get a document and you want to get it translated from a good official translator so that you know what exactly has been deposed. So my second stage would be do research comprehensively prior to drafting. Our experience shows many a times High Court has relied upon a judgment very heavily, and by the time the matter comes for drafting, either the judgment is overruled or it is referred to larger bench or some different views have come. Therefore, it's absolutely essential for you to do comprehensive research prior to drafting, which can help your client considerably. My third step would be, once you have done comprehensive research, once you have gone through the papers, you have to put it on paper and make your grounds. Basically 4 steps: synopsis, list of dates, substantial question of law, and grounds. All the 4 has got its own significance and objects. Synopsis is very important. You can, because somebody can form an opinion on the basis of synopsis. It's a brief on the set of facts and applicable law. You must convey your point in the synopsis. And so list of dates, we have to state what exactly is the list of dates on which particular things have taken place. But kindly keep in mind, when you are writing list of dates, don't suppress anything. Suppression is taken very, very seriously by the courts. And if by chance that suppression is identified with you, you will take long time to get out of it. When you are writing a ground, you must find out your first few grounds to be crisp, direct, which convey your case with clarity. You can keep on writing up to ZZ or ZZZ grounds, but that is not going to help your client. First few grounds are useful and helpful. I remember an incident when I found the best of the grounds at number ZZ. And when we argued before the court first put a specific question that this ground you have not raised in the special leave petition. And then we have to tell that, yes, it is there, but it is at ZZ. Kindly keep in your mind that your best points, which are there with clarity, must come in the first few grounds of your grounds. Another thing you should avoid writing is he or she or them or this or that. Because by the time you are in Supreme Court, terminology is already fixed. Either it's somebody is accused or PWs, DWs. It is advisable to use that language instead of using this, that, or name of the person. Another thing you should avoid doing is using offensive and abusive language. It does not help your client. At the same time, it can be fatal to your client's case. Always avoid using any abusive or offensive. Sometimes you can use my fourth stage, that is proofreading of your SLP. I remember an incident.
Kiranji,
My SLPs are written and
Kiranji, there is a complaint that your voice is cracking.
and
Maybe if you disable your video, it will be more
is it?
clear.
Oh yeah. I'll do that. Am I audible?
Yes, much better.
Yeah, that's therefore, I remember an incident which is from the beginning, in the beginning of my career. There was a course title written at the bottom of the course title. You know, we write the Honorable Chief Justice of India, and thereafter the SLP starts. I did proofreading for the SLP, but when the matter came up before the court and court asked me to come to a particular page, which was a course title. When I went to that page, I realized that my typist has written T in place of C. So it was a biggest blunder. It was embarrassing in the court. Of course, judge was very kind. Therefore, we should avoid such type of embarrasses in the court if we go through the papers again. I remember somebody briefed me in a matter. I saw some grounds, very well drafted grounds. But when we went to list of dates to see the dates or to note down the dates, he was appearing for the plaintiff. He has written excellent grounds, but probably so while writing list of dates, it was copied from the defendant's appeal in the High Court. And it said the plaintiff filed false and frivolous case, which you could have avoided if you would have seen it again. Such type of typing errors, especially of dates. I remember an incident that I wanted the court to rely upon a date because that was the SLP in which we were more particular about the cutoff date. Court's observation was that we have stopped relying upon the dates because so far as dates are concerned, they are never correctly written. And in this SLP also, you are relying upon a particular date, but in 3 pages, date has come differently, 67, 77 or 97. So therefore, you kindly go through your brief again. One more benefit you get when you go through it again is that you can always improve upon it. That apart, typing errors must be avoided. So far as advocate on record in the Supreme Court is concerned, you have a greater responsibility. Even if you get it drafted from somebody else, the moment you file it, you are responsible. In a bail petition, when we write, we have to write number of days you have already undergone. I got a petition in which, while filling up the form, it was stated how many days you have undergone, nil or NA. The court said, if you do not know how many days you have undergone, how do I and my registry come to know? Avoid such type of mistakes, which are not intentional, which just happens because we don't spend that kind of time while finalizing the draft. And now, so far as the drafting paper is concerned, Mr. Sishodia has given me 20 minutes.
Oh, no.
I am
Please take
already
your time.
nearing that. We need to give some tips on paper. I'm sure Mr. Sishodia will give tips. I will definitely say that so far as the paper is concerned, it's 100 marks, 4 questions, lot of options, 25 questions each. And I am speaking for myself, legible handwriting will definitely give you better mark. So Mr. Shishodia will explain what all the topics you should be more concentrating about. At the end, all the best to all of you for your year exam and have a good time. Thank you, Mr. Sisodia. Your turn. Over to you.
Thank you, Mrs. Suri, for such an engaging talk to all the aspirants. I must confess that unlike Mrs. Suri, I have never appeared in this exam. And even if we set the papers of these exams, I am sure that I would fail. Because to write so much, we have all gone out of habit. And this is the exam you have to write maximum. And as I was telling you that when you are presenting your case before Supreme Court, the first step is the drafting. Now, you have to be the first important thing about drafting, which and it would reflect in your drafting, is your general awareness about the development of law and what is happening in court. So as a AOR, as an advocate on record, you are expected to be a court bird, to be regularly there in court. So you not only know about the major judgments of the time, what are the latest pronouncements which are coming from the court, but you should also know which are the major topics on which the litigation is going on, what are the issues which are already before the court, and all this knowledge would make your entry or make the entry of your matter to the court much easier. So the first step for your drafting would be your general awareness, both on the substantive law, the case law development, as well as the current issues which are there before the court. And this, as court birds, you would come to know through the friends, through the regular attendance in the court, through the gossips in corridor, etc., etc. The second important part, when you sit in your office with drafting, or even when you are appearing for the exam, is taking the instructions and assimilating them properly. Now, taking instructions has so many facets to it. The first facet is to get full facts. Now, it is a very simple thing to say that you must have full facts. But when you come in the active practice, you realize it is very difficult to get full facts which are relevant for the case and which are relevant from the point of view of the court. And you have the wide spectrum of clients to deal with, from individuals who may not be aware of their legal rights, who may not be aware of the development even in their own matter, the legal developments. You may have the institutional clients where, the state government, suppose you are representing the state government, the things may not come, there is nobody coming to you every day and telling you about the case except the papers. Or sometimes the big ticket corporate clients where the whole information is so diffuse that the person who comes in touch with you may not have the full information. So in all cases, whether it is individual, whether it is corporate client, or whether it is other institutional clients, you have to be very particular about taking instructions fully. One of the, it's not only facts, because being for practicing in All India Court, you may come across cases where the special laws are applicable, which are special to that particular state from where your matter has come to you. Now, therefore, not only facts, but the special laws which uh, uh, are important. Uh, there is a demand for the question answer. We would have it at the end. Please don't bother. We'll have some time. Now, so this is one part of the taking instructions is the facts in the special law. Then you also have to decide whether you are going to Supreme Court in its appellate jurisdiction or the original jurisdiction. Now, as you know, that Supreme Court also has original jurisdiction when it comes to interstate a dispute. It may be a water dispute, it may be a boundary dispute, or it may be some other administrative aspect. Now, for the interstate dispute or the dispute between state and union, there is always a suit which has to be drafted like a plaint in the suit. Or you may have the statutory appeal, or you may have the special leave petition. Now, all these things you have to be very careful, because sometimes what happens is that suppose a matter is coming up from National Consumer Commission, and it is from the original judgment of the National Consumer Commission, against which there is a first appeal to the Supreme Court. But sometimes, out of sheer habit, sometimes people end up drafting a special leave petition even in that case. Now, a kind court or sometimes court in the interest of justice may allow the special leave petition to be converted into a statutory appeal. And sometimes they may dismiss it. So you may lose a good case for a wrong choice of the of the uh, uh, of the draft or the form of appeal. Then you must also go through the High Court and the lower court judgments, particularly in the civil matters or the criminal matters, the traditional litigation. The judgments of the trial court sometimes and most of the times are very detailed. You must go through them. You must see the basic pleadings and identify the underlying issue. Underlying issue in the sense of a legal issue, not what you think or what you would talk in a general talk with each other. So, understanding the underlying issue would help you in projecting that legal issue before the court, which can, in a good drafting, can appeal to the court in the very beginning that yes, there is a legal issue and it should be decided, and let us start to interfere or have a re-look at the judgment of the High Court or the lower forum, etc. So, identifying the issues in a legal sense is another very important part, in which you would concentrate both on the facts and the law, because there can be sometimes pure legal issues and not, sometimes there can be factual issues in the sense of interpretation of some document, which is also called a legal issue. But these are there are issues of which are mixed of facts and law, and there are issues of fact and there are issues of law. So you must identify all these issues and project them systematically so that the court gets a clear view. The you, as you must have all seen in your 4 or 5 years of practice in Supreme Court that the judges here come after reading. They really work hard, and a good draft with precision of the facts and the underlying issues which are well projected can really help your uh, can really help the cause of your client. Then after all this, you would also decide what is the appropriate remedy before the Supreme Court on the given facts and the legal issues. That is that is to that is to you have to take the call whether you must have a special leave petition or a statutory appeal or a suit or a Article 32 petition or just an IA. So suppose you have a matter which concern the forest bench. Now in forest bench, most of the time there's a debate whether you would like to go by way of IA or there should be a substantive petition or there should be a special leave petition against some order which has connection with the forest bench. So these are the so after taking full instructions, identifying the issues, and uh, you also have to then identify what in what form and through what remedy you are going to approach the court. The another aspect of the drafting is the language and expression. And there is sometimes we find that there is an indifference that we can say anything, but ultimately when we go to court, we will tell the right thing. That is not the correct approach. Your draft must have language which is responsible, expression uh, which are parliamentary, which are appropriate for a formal proceeding, which cover the entire gamut of your case on facts and law. And I must tell you one of my recent experiences that I was appearing for a judicial officer who was aggrieved by certain strictures passed in the judgment. And it appears that he insisted to draft the SLP, and in the synopsis, he wrote that the learned judge of the High Court has let out his own personal frustration, anger, and mala fide intent towards me. Now, this is a very serious allegation. Now, with all the sympathy for that petitioner and the inappropriateness of the strictures which were passed, the judges said that this one sentence in the SLP would disentitle you for any relief, and the matter was dismissed, and it created a very embarrassing situation in the court for a counsel to defend because the client is indulging in exactly the same thing of which he is aggrieved against. And this is where we have to be very careful about the language and the expression. And as Mrs. Suri said, that even if somebody gives you a draft ready from the, the court from where the matter has emanated, you please give your touch. Please apply your mind and avoid this kind of pitfalls where the the over enthusiasm or the anger of the client, which is not necessary before the court, though he may feel angry, he may feel whatever, but that's not needed for the pleadings. That's not needed in a draft SLP before the court. So you please go through that and avoid these kind of pitfalls where you end up with a very embarrassing situation. The other thing is that always project the legal issues. You know, even in PIL, sometimes there's a tendency to get carried away by whatever you feel or your feelings are on a given subject. But when you come before the court, so suppose you have a matter relating to pandemic, Now, you may feel very strongly about the injustice, about the deprivation, but ultimately the issue you are projecting before the court, it must have a legal bearing. It may have a bearing with the Article 21, right to life. It may have bearing about the discrimination, maybe that some people are given some benefit and your client has not got benefit, etc., etc. So always stick to the legal issues and avoid any extraneous uh, talk about the issues you are projecting. And you must have seen that we have a lot of senior colleagues at the bar who have a very distinguished life in public and politics, both in the ruling party and the opposition. But when they come to court, they talk only of law. And this is something you must always understand, that your draft or your petition or your pleadings before Supreme Court should reflect only the legal issues. One of the very interesting and problematic thing in the draft before Supreme Court is the question of law. And so many times we find that the question of law tend to be very bombastic. So somebody would say, has High Court not caused miscarriage of justice by the impugned judgment? Now, this is something which should be avoided at all costs, because this kind of bombastic language doesn't take anybody anywhere. Uh, and it only spoils the atmosphere for a dispassionate adjudication of legal issue before the court. And the other pitfall we tend to make, especially as young uh, colleagues at the bar, is the assumption that the matter you're projecting before court is the most unique. It has never arisen and it would never come. And you must have exclusive and the most important uh, attention from the court. Now, please don't get into that trap. There are 40, 50,000 cases uh, on the civil side and equally large number of cases on the criminal side and the other categories. So more than a lakh or two cases are filed in Supreme Court covering all kinds of issues. So please be restrained in your language, be sober in your language, and also please avoid the repetitions. As Mrs. Suri said, that so many times we have the grounds running from AA to ZZ to ZZA, etc., etc. Now, what happens is that in the process, you lose, and so many times you repeat the ground because you have not done the homework of focusing on the issues you want to project before the court. And in the process, what happens is that sometimes the important things are either omitted or they are said in a way that they get lost in the massive draft you are preparing, and you forget about ultimately your ability to, because you may not be able to remember yourself and you may not be able to project before the court what can be a real and a legal issue in your matter. So the repetition is, and it is a waste of time for everybody, waste of paper for everybody, and it doesn't really result into any benefit for you, except that you have not done the homework, and out of sheer laziness you say, let me say this also, let me say that also, let me say this in these three different ways, then let me say that in that six different ways, and in the process you end up repeating. So please avoid that and try to be more focused in your pleadings so that people who read it also have the pleasure of appreciating what is your point of view. And the related to this is the the precision which is expected, precision in the sense that uh, you have a given format now in Supreme Court for the SLP, for the suit, for the writ petition, for the criminal SLP, etc., etc. And now all that should you should stick to the form. You must uh, put your facts in a precise manner, in a date-wise manner. So, and there are occasions when you have to show creativity, but the creativity should not, in the creativity, you should not play with the form which is prescribed by the court. Stick to the form. Your creativity should be about the ideas you want to convey to court, about the arguments, or about the new facets or the nuances you want to project before the court. But don't have creativity about the format, because uh, for a busy judge or for a busy lawyer or a senior advocate you would be briefing, uh, they are used to looking at the things in a particular way, and the known format everybody is comfortable with. So whatever creativity you want to use, please use it for the ideas, for the arguments, for the issues, but not for the form. And uh, we would like to leave another 15-20 minutes for the question answer. So before that, before I conclude, I must also endorse one of the thought Mrs. Suri has given to you, is that to practice as much as possible, because this is not a paper in which you would be learning by reading any particular book. There is no book for drafting in Supreme Court. Uh, the only book, or as they say, that the life of law is experience. So for drafting, it is only the experience which matters. But till you gain experience, or till you gain more experience, you're already, all of you are already experienced after 3-4 years of internship, etc. Uh, you please draft till your exams and even thereafter as much as possible, whether it is a counter affidavit, whether it is a rejoinder, whether it is a SLP, whether it is a 32 petition, or whether it is a suit. And if you can't draft, or if you're not having access to the draft so much, uh, you please read the matters of the friends and the colleagues at the bar or in your office, the old matters, so that you get to understand that what is the legal way of projecting an issue. Because ultimately, the underlying idea in a drafting before Supreme Court is to project the issue and the legal issue your client want to agitate. And you have to always keep in mind that most of the time, unless it is Article 32 petition or a suit, which is relatively very low in number, the special leave petition, both on civil and criminal side, the matters come to Supreme Court after filtering in the 2 or 3 tier of our judicial system. So there is a trial court, there's a first appellate court, and the high court or the division bench, etc., etc. So you always would be having a, a 2-3 perspective. There are sometimes the concurrent judgments, sometimes there are differing judgments. So the single judge has taken a different view, division bench has taken a different view, trial court has taken a third view. So in this kind of scenario, uh, in a court where the matter comes up after filtering, it comes up before a very matured set of judges with a vast judicial experience before they come to Supreme Court, in a court of last resort where uh, where, and this is a very important part, that the client who has come to you, for him, this is the last resort, because after this court, they would not have any other remedy of appeal or even the special leave petition or whatever. And the projection of the legal issues properly is of the utmost importance. Now, with these thoughts, I would now request uh, uh, Mr. Goyal to allow question one by one, uh, so that we can have at least say 10-15 questions in next 10-15 minutes.
On the chat box, somebody's asking if the question, just 1 minute, I'll read it.
Yeah. No, you read and answer it, please.
If a question does not mention to draft certificate or an affidavit specifically, will it be required to draft the same? I say no. You please read the questions carefully. Whatever we don't want from you, we have specifically stated so. So it is not necessary to draft or write something which we have asked you not to do. That's one question. Second question I find is, how important is mentioning supporting case laws for purpose of this exam? I am not able to understand what is this question.
No, maybe that sometimes, you frame in a question of
Oh, yeah.
law about the impact of some judgment you have in mind, which covers that subject.
Yeah, it
So
would be
you
important.
you may, in a
Yes.
given case, use that. If we go to the chat box, there's so many things. So I don't. Uh, 1 minute. How do we? How do we? No.
Anybody
How do
want to ask a question can put in chat box also. We can answer straight away.
No, but what happens is that chat box, you see a question flashing on you. Uh, so now somebody has asked that what are the important topics for the exam? So
Yeah.
the important topics are whatever the drafting skills you need in Supreme Court would be important for your exam also.
No,
Now, here you
I
would have the
can
instructions which are very precise. So
I can tell you 2-3 aspects. One is there is no question of tax law on tax law. Let's make it easier. No
yeah.
question on tax law, and we have some. We can filter some of the subjects to make it easy, because after all, anyway, we are only examining the drafting skills and nothing else.
So instead of subject, I mean, our examinees must know that they would be required to draft SLPs or the writ petitions or
Yes.
the plaint or the counter or the rejoinder. So these are the normal things which you need
Or
in your
or
day-to-day
section
practice
or
is part
section
of the exam.
11 or transfer petition.
Yes. So these are the usual things which are needed in uh, in your day-to-day practice, would also be there as part of your exam.
One question is whether a memo of parties list of dates synopsis is required to be drafted in the exam unless the question specifically requires so. I'll tell you on this. I can answer this question. See, we have specifically stated in the question what exactly we are looking for from you. And synopsis is not required, list of date is not required. It is stated on the affidavit, on the question itself. Question is very clearly stating all this. Only go through the papers. Go through that question paper and then you will know.
See, our examinees must be sure that whatever they draft is not going as a matter before the Supreme Court judges. So, all these formal things which are part of our SLP may not be needed, because
Yes.
what is the substance of the matter before you and how you are going to project the issue. That is the criteria to judge in an exam, and you would not need all these formal things which are part of the SLP, because that is not needed, and it would unnecessarily take up your time to write the subject, etc., the certificate, etc. So that is not really needed.
We are all aware that format of SLP is already on the computer of everybody.
Yes, yes, yeah. So therefore, it is difficult to write what is there on the computer, and this is where. So now I am able to now go through the questions one by one. So I'll just mm, so in the beginning there were a lot of procedural issues, and now some
One question is, since it is lengthy paper, how much are we supposed to write for each question? Any guidance on that?
no, that is your choice. Uh,
You can
because
go up to TT.
if you write precisely, you may end up writing less and covering everything. And if you go in a haphazard manner, then perhaps you would be writing too much, but at the same time omitting a lot of relevant things. Now, this is
We are
where
not, we are
your
not going
skills
to
would
give marks on the basis of your lengthy answers.
absolutely,
Yeah.
absolutely, absolutely. So till uh, so ask someone whether any judgment to be mentioned in the ground. Is it mandatory to incorporate? Now, you see, I must tell you that good drafting is that you state the principle and raise the ground on the basis of principle. And at the time of argument, you cite the judgment. But sometimes you relate a principle to a judgment, and then you cite the judgment and talk of the principle. Now, these are all matters of style, uh, and sometimes citing too many judgments sort of tie you down and bind you to a particular argument, which you may or may not ultimately take up. So, my general advice is to avoid citation or have least of the citations, unless it is a very settled position in law, and raise the argument generally. Then
Whether curative petition will be after the RP heard in open court? What is this?
no,
No, yeah.
we can avoid the question which is not related with the drafting. But this is to do with the
If only question of law and grounds are asked, then we need to draft only those or entire SLP from cause title.
no. So you read the question and answer according to that.
Yeah, you read the question and answer, because everything is very stated very clearly.
Hmm. Now there have been a lot of complaints about the quality of audio video. Now nobody knows in this kind of scenario whether the problem is with us or with the person who's hearing us, or with the system. So
Yeah.
uh, we have to all bear with whatever
Yeah.
has been the.
One question which is asked is whether verification is required.
Not in the question paper,
Yeah.
but of course otherwise it is mandatory.
No, but yeah, because
So
when they are drafting writ petition, verification is part of it.
very well.
SLP or any during drafting SLP or any petition, can we see on affidavit page or certificate page on the place of memo of parties, please refer at page number so and so, and lead the checker to the first page so that we don't have to write the memo. You don't have to write memo of parties again and again, and we have given it very clearly on in the question paper. In the format of SLP, how to present of issue of facts as issue of law might be covered under questions of law. I think this is part of your drafting
Yes, part
skills.
of your judgment and
your drafting skills.
skill.
And,
Your drafting is that is what you would be tested for.
yeah.
So
Does one have to write the rules along with substantive law provision in the title?
rules of
Rules along with substantive law provision in the title, probably. I don't know.
no,
No.
that is now as per the new format.
Yeah.
At the end of SLP or at the end of
You
the
need to write appendix.
you need to reproduce the provisions of the law which are
Yes.
mainly applicable. So
Do citing latest or precedent judgments will fetch more marks in drafting? Is it mandatory to put all necessary case laws in the respective transfer petitions, sir? A little insight.
no, I must warn
What?
people that you may know all the latest case law, but if it is not relevant to the question you are being asked,
Yeah.
or the topic you are drafting, it would be an unnecessary show of knowledge and occupy your time. And instead of giving the right answer, you would be writing a wrong answer. So please
But
avoid this.
in case there is some judgment which is relevant, you must point.
Relevant, yes. It would depend whether it is relevant or not. And according to the relevance, it would always be helpful.
If one person says tax appeal should also be included, why exclude tax matters in drafting? No, we don't exclude because we have to give only 4 questions to you. We cannot have all the subjects.
No. This session is not for taking any advice. What we thought in our wisdom we have done. Now you do according to your wisdom the papers. So let's not get into this.
Rest is repetition, whether we should put cause title and all this. I don't think we have already answered that. And declaration also we have already answered. Will the question paper provide facts of the case? Yeah, whatever is necessary to for drafting will be given in the paper.
Now there is one question that, sir, what is the ideal way to draft question of law? Should they be case-centric or general? Since mostly courts entertain substantial question of law, similarly are grounds essentially petitioner's version or answer to the question of law. Is it advisable to quote precepts of the judgment while pleading? So this is a good comprehensive question. And as we have already told you again and again, that partly it is a matter of style, because some lawyers are more comfortable with, even of talking about an idea, they are more comfortable with talking about that idea with reference to a decided case. And there are lawyers who like to talk about the idea irrespective of the case, and then as the argument proceeds, they support it with the given relevant case law. Now, it is my personal view that a good drafting should not have so much of a case law, and because you have to remember the correct case law, especially in the exam, and you may end up quoting the wrong citation. It may be the year, it may be the page, it may be the name, etc. And it will take unnecessary time. So for the time you take to write the citation, you can write a good sentence about the issue or the gut issue in the matter. So, and also as a in generally speaking, when it comes to a good draft, the because you are before the court of last resort, because you are dealing in a with a court where the matter has come after filtering through 2 3 layers of the court, uh, it is always advisable to first put your contention, the issue, or your argument in a general manner that it is acceptable. And then, as and when it is argued, you support it with the case law. So, this is my advice that the pleading should avoid as much as possible quotation of the case law unless it is really very necessary and you want to project one particular thought uh, thought in the pleading which only that judgment uh, sort of projects, and that is the main sheet anchor of your argument. Otherwise, have a general pleading.
There is one question that did you mention there would be 25 questions of which we would have to answer 4, or did I miss here? You miss here.
No, not 25. Don't worry. It would be what is normally possible and what has been possible in past. We are not departing from the format of the paper as it used to be in the past.
Correct.
So the substantial question of law should sound substantial on face of it, without the aid of the case law, etc.
Last 4 years question papers would be helpful. Question is yes, of course.
Yes, of course they would be helpful because that is the pattern we have followed, and whatever is being asked in the years gone by, something like that would come in a different form. So, so they would be relevant, no doubt about it.
One question is, ma'am, do we need to make a space arrangement like legal paper, or we can write like the answer sheets? You write like answer sheets. We are not looking
Yes.
for your spacing.
It should be legible and understandable to the examiner.
The one question is whether short forms can be used while writing answers, that is TP Act, DV Act, etc.
Would depend on the given case.
Yes. You can't write yeah like that type of. But
Yes.
of course, if TP Act you have written, we understand what it is.
Yes, but still, as far as possible, because there's so many acts which may sound similar if you go only by the initials. So.
Now, there's a question to you, Mr. Shishodia. Sir, what is the difference between affidavit and verification?
So affidavit can be of anything. Verification is at the end of the affidavit that what you say in the affidavit either is true to your personal knowledge or the record or whatever the source you have. So that is the verification. So verification is part of your affidavit.
There is a lot of case law on Order 6, Rule 14 and 15. Go through that.
Yes.
Can you please give some light on question of and substantial question while drafting means how to draft question of law?
No, so as we briefly mentioned that please avoid a bombastic language. Please be precise, project the legal issue. That is the question of law. And what is the legal issue? You would find after reading the problem properly and applying the law applicable to that legal problem properly, and then bring out the legal issue.
One question is 30 minutes reading time will be there? Yes, it will be there. Number of questions that will be asked for and how many options? You have good options, don't worry. Questions are like you read for last 4 years. We have followed the same pattern.
Now, there's one question about, what would be essential in the SLP grounds or question of law. So on a given question, you would get the details that what is expected in that particular question, whether what is expected is only the grounds, or what is expected is only a synopsis, or what is expected is a full SLP. So you will get the instructions in that particular paper.
One question is, should the ground start with because, or can it be mentioned as a general submission starting from that?
It's again a matter of
Your
style.
individual,
Some
yeah.
people start with because, some people start with
Start
it
with
is
that.
submitted. So
That will
it's a
not
matter
add
of
or
style.
that will not add or subtract your marks.
Yes. No, it's a way of saying things. So
Yeah.
everybody has a different way of saying things.
Is there any mandatory question? Of course, when we give you 4 questions, we want if it is SLP should be there. You must draft that. It's not that you can draft only transfer petition or counter. But they are mandatory to be drafted. Compulsory questions.
So there is this question that what is the ideal way to draft question of law? Should they be case centric or general? And mostly the court entertains substantial question of law. Similarly, are grounds essentially petitioner's version or answer to the question of law? Is it advisable to quote precepts of the judgment while pleading? Now, we have answered this already. The question of law, sometimes, you tend to frame in a manner that, is injustice done to your client, or something that is the conviction justified in the facts and circumstances. So that is not the question of law. The question of law would be that, suppose there's a dispute about the nature of evidence which has been considered or not, or in a civil matter, uh, particular relief, which can it be granted when the prayer is something else. So these are the things which would depend on case to case basis, and
No,
this
we
is
take
where
the law probably.
your understanding and your creativity both would come into play.
Now, the last question probably we'll take is minor spelling mistakes or grammatic errors mistakes will matter or not?
Of course, they will matter.
They will matter.
We must, everything matters, because ultimately what you project. So if you are projecting so casually that you are not clear about the language, or the minor language, as Mrs. Suri pointed out, that chief becomes thief. So that is something which can't be termed as minor, so to say. So
that is a
everything would
blunder.
matter. Everything would matter in exam. Everything matters. So please try to be as precise as possible. And I think we must now convey our good wishes to all the participants. Thanks for being with us and sharing whatever little empirical knowledge we could share with you. Thanks and all the very best.
Thank you very much, and all the best to all of you.